good morning, ladies and gentlemen. The first thing we're going to do is watch the videos that you all requested, and then I'll move on to answering the questions. All right, go ahead with the first one.
Oh, we'll actually get to see the video. We get to watch it again. Here we go. Y'all remember Brian Steele played this too. Said, did you see Jeffrey Williams at this gas station at all? I said, nope.
Excuse me, Your Honor, may we approach?
And somebody was asking about a hung jury. If there's a hung jury, then it would be a mistrial, but they could retry it from my understanding. But I think we're still, the jury's still out on that.
Camera 10 at 1844:31.
I believe in this instance they could retry, but they would have 30 to 60 days or something like that. Don't quote me on that part. But if it's a hung jury, it would be a mistrial. Yep, you know it, Joshua.
We're not sure exactly which getting into the car you meant, so we're just trying to show all of them for y'all, okay?
Joshua Van Lawn said, I knew that was going to happen because the prosecution didn't show the defense the video first. So now they're doing more shady-ish. Yeah, of course. Yeah, let's show them the whole thing. Let's get them to ask more questions. I don't know why the defense wouldn't have indicated a clear start and stop point for each one of these videos. Like, just take the time and go through it. And we'll start at this point, start at this, stop at this point. I get it. They're ready to get out of here, though. And they're approaching again. The video's still playing, of course. Why would they still play the video while... It's all a mess. Dear Well Christian says, asking the state to represent represent, video evidence is scary. They're doing to Brady that thing like an 80s TV show. Oh yeah. Joshua Van Lawn, the Honorable Attorney Joshua Van Lawn says if there's a hung jury, they can bring the case again as if it was never tried before. So all the evidence can be readmitted. They can also use transcripts in some cases from the prior trial. Yeah, that would be interesting. Is there a time limit on that, Attorney Van Lawn? I think it's like 30 days, right? Let me see if I can find that out.
So, Your Honor, at this point, for the record, we're going to stop it and stop sharing and then fast forward to the next point that he gets into the car.
Okay.
We're stopping at 18:48:17.
And he said it doesn't have to be the same judge, but it most likely will be. Yes, and as I mentioned before, a hung jury is a mistrial. I think they only have a certain amount of time to retry this, though. I just can't remember what it is. Oh, 6 months. Excuse me. So not 30 days, 6 months. The state may re-indict the defendant within 6 months, even if the original statute of limitations has expired. However, in the case of a mistrial due to a hung jury, the original indictment remains valid and the statute of limitations is not a concern. Therefore, the state can retry the case without the 6-month limitation imposed by 1733. The decision to retry typically depends on the factors such as the strength of evidence, the likelihood of securing a conviction in a subsequent trial, and considerations of the judicial economy. So they have as much time as they want.
So that was the second time he got in the car. Now we're going to fast forward to the next time he gets in the car. Okay. Which will be at 19:15:52. We're fast forwarding to that.
So Joshua Van Lawn also says there's no way a judge would ever grant a new trial on the basis that no reasonable juror could have convicted these guys. So then what would she... And he said the timeline is up to the prosecutor whether or not the DA stays on or she assigns someone else. Wow. Yeah, they would get Judge Whitaker out of there. you know Fanny does not like Judge Whitaker. Well, we don't know that, but I don't think she does. She's been too defense friendly. So another 10 years.
Satisfy what y'all wanted to see on that?
No, that's not the last time he got in the car.
All right, sorry.
We're fast forwarding.
Sorry, thought y'all said 3 times.
So we're now fast
My
forwarding.
bad.
Fast forwarding.
She said, my bad.
19, 17, and 10.
These niggas lacking.
No, there's no way they would want Judge Whitaker back on this.
Those are the times that he,
Does that satisfy what y'all wanted to see? Y'all are nodding yes. Okay. All right. Now we'll move on to the barbershop video.
Your Honor, and for the record, it's 292 Yankee Alpha, and we're starting at 8 minutes and 22 seconds of that exhibit.
Here we go. And we're going to play through how long? Someone get them some water. Dang.
Your Honor, may you inquire if there's any more of this video? I'm stopping for the record at 9 minutes and 14 seconds.
All right. Does that satisfy what y'all wanted to see on that, or is there a different angle or more that you want to see? That's good. Okay. That's what they wanted to see. All right. Moving on. Sorry. Good. Okay. All right. Moving on to the questions. Mr. Weinstein said the watch. However, remember that nothing that the attorneys say is evidence. All right, moving on to the next couple of questions.
Oh, man, that's funny. Well done, Doug Weinstein. Well done.
All right, on count 58, possession of marijuana with intent to distribute, the state must prove that Mr. Kendrick knowingly and intentionally participated in or helped in possessing marijuana, intending to unlawfully deliver or sell it. Does that cover what y'all are asking with regard to that one? Yes, okay. All right. Moving on to whether you need to group counts 57, 58, and 61 individually or separately. You will need to consider them individually and reach a verdict as to each of them separately, but possession of marijuana with intent to distribute would need to be proven for count 58, count 61, and count 57. Does that cover what y'all wanted to?
Still confusing.
Okay. All right, then I will excuse y'all to continue deliberations. Thank you.